Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we are discussing administrative processing and some changes with respect to the policy on administrative processing. And for those who are unaware, what is administrative processing? Well, administrative processing is basically, it's sort of a term sometimes referred to as bureaucraties, sort of the internal language of the bureaucracy associated with visa processing. It's sort of that language's version of, well, we're reviewing it. So it's kind of a catch-all term. I know a lot of other immigration lawyers get kind of angry when they see administrative processing. I've never felt that the Thai embassy here, the U.S. embassy here in Thailand, I should say, I've never felt like it was overly abused. In the cases that I've seen administrative processing, they were usually cases that were dealing with rather atypical fact patterns and they just had to be reviewed over more time. In certain cases, administrative processing also meant that the fraud prevention unit was reviewing the case and required further adjudication. So it can mean multiple things. I've seen it used with a lot less I've seen it used with a lot less frequency in the past roughly 18 to 24 months, but there has been some changes with respect to how we're going to be dealing with this in the future. So this is actually from the Department of State website, that's travel.state.gov. Title of this announcement is Visas CEAC, that's CEAC, which stands for Consular Electronic, Consular Electronic Application Center. I can never remember some of these. CEAC case status change. Quoting directly, on March 3rd, 2020, the Department of State made an update to the Consular Electronic Application Center, CEAC, website, our online portal for visa applicants. A visa applicant whose case previously displayed as being in administrative processing on his or her case status page now displays as being, quote-unquote, refused. There has been no change in such applicants' actual cases. This is an administrative change to more accurately communicate case status to applicants. Quoting further, visa applicants whose case status on CEAC had previously displayed as administrative processing had been refused under Section 221G of the Immigration Nationality Act. Although some refusals under the INA Section 221G can be overturned, the change in the CEAC correctly reflects that the applicant's visa application has been refused. So 221G is a section of the INA which basically stipulates that an officer essentially can refuse a visa application for insufficient documentation. We deal with 221Gs rather frequently at the U.S. Embassy here. It just happens. They want to see more documentation. Sometimes there's a deficiency. Sometimes things just happen. They want to see something else. And a 221G refusal is issued. The thing I don't like in this that's noted in here is that they say 221G refusals can be overturned. The change in CEAC currently reflects that the applicant's visa application has been refused. There's kind of an implied notion here. I think they're trying to imply more finality there than really exists in a 221G. If you get a 221G, it doesn't necessarily mean that the case is over. In fact, quite the contrary. 221Gs issued here at the embassy in Thailand and embassies elsewhere often will state that you have a year to follow up in order to deal with it. And they use the term overturned. That's not exactly what's going on here. I prefer to use the term rectified. There was a deficiency, you rectify the deficiency and move on. Overturned, it sounds like being overruled in a courtroom, like on Perry Mason for something. It lends a lot more gravity than I think really exists in a 221G. A 221G refusal is simply that. You've been refused under 221G. There's a deficiency. Here's the deficiency. If you can overcome the deficiency, then we can go ahead and move on from there. So the thing to take away from this video is they have changed the name from administrative processing to refusal. but do not get overwrought. A refusal may not necessarily mean that you cannot get a visa. In fact, we'll make a video on that specific issue here shortly. But the thing to take away from this video is just because you've got a 221G or just because on SEAC it says you're refused may not be the end of the road. That refusal could be, as they say, overturned, as I prefer to say, rectified, and you can move on down the road.